In this case, the prosecutor was required to reset the trial date or move for a continuance before the second-day period expired on June 23. The result of a failure to conduct the hearing within 60 days or to obtain a good course continuance is a dismissal of the state's complaint. The state argues, and that's what the state's arguing here. I'm reading again. The state argues that Roosevelt waived his right to insist upon the 60-day statutory requirements because he initially requested a continuance, which I said I did not request a continuance, but. And this is what the court wrote. The state knew, however, before it scheduled the trial for April 24th, that the defense was not available then and had specifically asked for the trial not to be scheduled that day. Nevertheless, the state noticed the trial for April 24th, which prompted Roosevelt to request a continuance to the next available trial date. Pre-admitted whether Roosevelt request for a continuance acted to waive a trial for the first 60-day period, the evidence does not show that he waived the time of trial within the second 60-day period that had yet to begin. The state also argued that the trial judge found that Roosevelt waived his right to insist upon the statutory scheduling requirements by participating in a fruitless discussion to reschedule the trial. The record does not support this finding. Rather, the record shows that the Superior Court orally granted a motion to continue on April 21, after which nothing happened for more than a month. And it goes on with those dates. Skipping to the next paragraph, Your Honor, the Supreme Court of Georgia articulated the principle that forfeitures are not favored and should be enforced only when within both the letter and the spirit of the law. Before the state may forfeit a defendant's property, it must comply with the rules that afford the requisite procedural safeguard. The burden is on the state, not the defendant, and this is what I stress. Thus, Roosevelt is correct by asserting that it is not his duty to assist the state in depriving him of his property. The forfeiture statute requires the state to timely initiate the forfeiture action seized. Your Honor, what happens here, and I have three different ways to look at this, and each way I believe is the claim that Mr. Williams makes. The first way is there's a stay in place. Signed the court on March 17, 2025. It goes to the court, to the parties, and we're going to have a trial on May 5. That stays lifted, unbeknownst to me, but it's lifted on the first day of April 2025. That gives, if you use that date, that gives the state a capital salary. All of April going into May, and May going into June. So June 2nd would be the 61st day. There was no trial then. The state says that I waived it because of my conflict letter. The case law says I did not waive it. I then write to Your Honor Court for 60 days, and now I'm up in New York, and there's these great lawyers. It was an exceptional experience in my life. There's these great lawyers there, and it's different than all these other cases. I'm not the lead. I'm part of this team, and there are times that I just help people, and I don't have any witnesses, so I want to accommodate. I know the 60-day period, so I felt the duty. So I wrote to Your Honor Court, and I write to Your Honor Court, and I explicitly say that I'm available in May. Even if you go by the date of the stay as April 1, May 1, June 2nd, it's going to be the 61st day. I am alerting that I'm available in May. This is May 21, and I am available in June. Let me know. Nothing happens. The state, and I am not picking on the state, I'm just right to the law. The state never advises this court, hey, we have a 60-day here, we need an order to continue for good cause. They're silent. The only one reaching out to court is me. I'm the only person. The state never initiates these communications. So to me, April 1 to June 2 happened, no trial. Yes, I had a conflict, but I had amended that conflict to say I can be here, and all that is in Exhibit D, my file. And I sent it to the prosecutor, and I sent it to Your Honor Court via email. What does happen, though, is Your Honor Court states, and it's my conflict, we're not going to go forward with with me, and the court removes the May 5th date, as I said, on April 22. I am not saying that's for good cause, and I'm not saying that should erase the April 1 date. But even if it does, I believe that Mr. Williams still is the claimant who gets back the property, because now we start with the date of April 22, 2025. In the case of the right, RICO.
It's written by Judge Barnes. Can I have just 1 second to...
Sure.
And if the court, I did not cite this, I didn't do it on purpose, I just found it.
That's fine. I don't have that case, so if you'll just give me the site, I'll pull it up on Lexus.
Okay. It is Rice 246 Georgia Appeal, 414, 541 Southeast 2D 58, 2000. Any questions?
Sure.
So the reason I thought Rice was important for this exercise, Your Honor, it's on Division 2, the prosecutor is reading along, Your Honor, that's on page bottom center, 3 or 4 of the copy of the report. And the Court of Appeals wrote, Division 2, although we have doubts about the propriety of granting an ex parte motion for a continuance under these circumstances, we do not address.
Slow down for me, please.
Yes,
There's
ma'am.
something wrong.
Sorry.
Thank you.
Although we have doubts about the propriety of granting an ex parte motion for a continuance in these circumstances, we need not address that issue because we find that the trial court erred by denying Rice's motions to dismiss the forfeiture complaints. Even assuming that the grant of the continuance was authorized initially, more than 60 days had elapsed from the date the continuance was granted until the trial court denied the motion for reconsideration on September 14, 1998. So what I learned from that case is we then go, which makes sense, the 60 days doesn't reset, in our example, April 1, 2025 to June 2, 2025. And then the state gets from June 2 to July, or to August 2, 2025, because they would have additional more than 60 days from the date of the grant of continuance. So this really, that's what I thought, but this case really helped, that we do it from the date the continuance was granted. Well, the continuance that Your Honor before granted was on April 22, 2025. So if that's true, now we have April to May and May to June. So by June 23rd, 2025, more than 60 days have passed. That's June 23rd. The state did nothing in that period of time. I am announcing to the court I am available. The state is silent. It is their duty. It is not the court's duty. It is not Mr. Williams' duty. Nothing happens, and then the court's next statement about scheduling is the next day. It just happened to be June 24, 2025. That's 62 days after April 22, 2025. That sets a schedule for August 18th. So we went, the state is now asking the court to ignore the fact that I did not move for a continuance on behalf of Mr. Williams' appointment. I sent in what I'm required to do. I uploaded an amendment to it saying I can be ready. The state is silent. Mr. Williams goes from April 1 all the way till June 2 without a trial. It's not the court. That is the state of Georgia. Mr. Williams should win. Claimant should win. If you want to, not you, but if the court finds that, hey, there was good cause, this is what I'm finding, my April 22, 2025 order is in place, it's within the first 60 days from the lifting of the stay, I'm not conceding that, but okay, even if that, go under that scenario, then 60 days would end on June June 23rd, 2025, without any word from the state that 60 days is going by without the hearing. And I'm making myself available. I put that in writing. I can be there. So I think the state is in.
I just think they're out.
Now, let's just say, I'm not saying it's true, but let's just say the court finds that that stay is irrelevant,
Or you didn't get notice.
so we're not doing the stay. Mr. Williams still wins. Then what happened was, according to the records,
The last person accused in the
case related to
the underlying, related to this case, the
civil forfeiture case, the immigrant forfeiture case, was stayed by the former, the first judge on the case until the last person resolved their case. So that would be on June 10th.
that's an automatic
Everyone's on notice, that's what the order says, the stay is over.
60 days starts right then.
Well, 60 days starts from June 10th, which is we take the next day, June 11th, because we always count. It's on the next day. So I counted this, and that would run on the 12th day of August, I think it's the 11th, but I'll say the 12th day of August of 2025. The court entered an order on June 24, 2025, so that's after Mr. Eppinger, EPP, and GER, resolved his case, but set it for outside the 60 days from June 11th. And the state is silent. And under Roundsville, I would be violating the law by
Alerting the court.
But what I do, your court asks, are you available the weeks of July 21, 2025 or July 28, 2025? That's within the 60 days. I don't know about the state at the time. So I'm thinking, the state must have alerted somebody. That's fine. And I write back, yes, I'm available both weeks. And just let us know. The state says they need more than a day, they need a day and a half, and then it gets scheduled out. There's no mention of anywhere in any of these orders for good cause shown. There's zero mention of it. The court would have to do it on its own. This honorable court would have to say that regardless of the fact that the state did not do its job on getting the court aware of the 60-day limit, and instead of putting it on claimant, which it can't do, then somehow the court says the court's taking the position that it was for good cause. It's never written anywhere. That would be the first time anybody would said this is for good cause. This is not on the state, and I'm not blaming the prosecutor.
I'm confident as reason for this that the prosecutor has to or try the case within 60 days.
That did not happen. Your Honor, I just gave
All three scenarios that I could come up with.
there are no other dates here. I found, and then the state, let me just address this. I did respond when I saw the date on June 24, 2025 being today, August 18th. I mean, it's just my nature. I did respond.
In fact,
It's in the
thank you so much. See you all soon.
The state says that thank you so much
Somehow is me
agreeing or waiving my 60 days on behalf of Mr. Williams. I don't have to object. And I'll give you that case as well. Give me 1 second. forfeiture statute requires the state to timely initiate a forfeiture action of seized property. That's runs afield. The state failed to schedule the trial date or request a continuance within the second 60-day period following the filing of the complaint. That's also runs afield. But I have the exact case, Your Honor. Give me 1 second. I'll get it. Goodwin, G-O-O-D,
W-I-N versus State,
321 George Appeal.
548-739 Southeast GD 814, 2013.
Would you like to
Copy.
No, I've read it. Thank you.
And in the footnote 7, the court wrote, there is no evidence that Goodwin
consented to a hearing date outside of the 60-day deadline?
rejected, and then it cites a Griffin.
Griffin, 250 Georgia Appeal at 9495 Division 1.
Rejecting the state's argument
Argument that claimants waived their right to a speedy resolution of their property rights by failing to object when the hearing was scheduled on a date outside the mandatory 60-day period. You know, I would be doing Mr. Williams a disservice. Now, I did see it. I'm not trying to game anybody. I'm going by the rules. And I felt bad. I told Mr. Rude that. I told him, you know, I told him I think that you're out of time before I file that motion. I told him that. And I still think that. I will answer any of your questions, but otherwise, nothing to do with the facts of the case. It's just on this.
Thank you, Mr. Steele.
I have nothing to add, Your Honor. We'll stick by our response. I don't want to belabor that point by just repeating our response.
Thank you. I do believe that it is correct that notification of a legal conflict does not equate to asking for a continuance. You know, I think counsel, we all feel like that people worked hard in good faith to try to find a hearing date, and we ended up with the hearing date of today. But the procedural rules and requirements of these forfeiture statutes are mandatory. The statutes are strictly construed against the state. There was no request at any time for a good cause finding to move the hearing outside of the windows that are statutorily required. I don't believe that acknowledging a hearing date operates as a waiver. The burden remains on the state the entirety of the time. And like I say, there was never any kind of request to the court to find a good cause based upon the hearing date being set for when it was. And I think that the court has no option under the case law and under the statutes but to grant this dismissal. So the dismissal is granted. And I don't know whether the state has any intention of appealing or not. And that's not a determination you'll have to make right now. But I would imagine if there is an appeal that the piece of property will be stayed until after that is sorted out. But at this point, that's the court's ruling. Thank you all.